I'm Drew Stevenson, and this is a lecture for my administrative law class about Heckler v. Campbell, a 1983 U.S. Supreme Court case about controlling agency adjudication through rulemaking. Now, in this case, this is another one of our Social Security disability cases. And here, the big picture is that the agency wanted to kind of streamline and constrain the decision making of its adjudicators by publishing a grid or table or matrix that they would follow that would produce more uniform decisions. So let's go back to our slides. So again, the big picture about this case is that this case is about the legal validity of agencies promulgating a grid or table for deciding a case rather than to have individualized determinations that consider the totality of the circumstances and nuances of each case. In 1978, the Secretary of Health and Human Services, who was Margaret Heckler, that's the Heckler in the caption of this case, promulgated regulations for the Social Security Administration disability determinations. Now, SSA sorts claimants into two groups: those with a listed specific medical condition who cannot perform any gainful work, and those with less severe impairments. So without going too far afield, there's sort of two rubrics or tracks you can use to pursue a disability claim. One is the listings, which basically are sorted by body system, like musculoskeletal or heart and pulmonary, and then list the level of severity or of injury that you have to have in order to qualify under that. And it's very difficult, it's very rigorous, and you have to have a lot of testing and documentation. So then they have this other category of people who maybe have been given a sedentary work classification by their doctor due to a sort of a combination of factors, maybe their weight and their age and their back pain and their psychic state, and their and now they can't find a job because of their skill set. And for the latter group, HHS adopted a grid, which your case will call the Medical Vocational Guidelines. Practitioners in this area still call it the grid, but the cases call it the Medical Vocational Guidelines, and this has been codified in the federal regulations. And it basically is a table that bases things on four factors that were flagged in the agency's enabling statute: physical ability, age, education, and work experience. And by physical ability, again, we mean like you can only do light work, you could do medium work, you could do heavy work, you can only do sedentary work, and so forth. Now, this is an example of the table. The picture down in the corner is Margaret Heckler, who had a distinguished career in politics in the 1970s and 80s under the Reagan administration and in Congress. So this is table number 1 for sedentary work, and you'll notice on the far left it has age and then do, or do, which is basically just supposed to be id in Social Security talk. And they have clearly defined in the regulations what they consider advanced age, which is, let's say, 60 to 64. And then they're going to look at how much education you have, and you're more likely, basically the idea is that the Department of Labor and their vocational experts at Social Security said that the less education you have, the less jobs there are that you can switch to as you have diminished physical capacity. And the same is true of previous work experience. So you'll notice in the far column, it just decides disabled, and then do or do means ditto. So if a person only had unskilled or no work experience and they're this age and they have limited or less education, which again is defined in a definition section, they are statutorily disabled, the judge at an ALJ, for example, has to grant benefits. But notice if they have even transferable skills, then the decision changes to not disabled and so forth. So that kind of bounces back and forth on this. And so if you think about a super specific skill like removing changing horseshoes on horses or something like that, there's not a lot of other jobs you can take and do with that. On the other hand, if you were a telephone switchboard operator or maybe an auto mechanic, well, even if you can't go back to being a car mechanic, there's other types of repair work and systems work or training that you could do even if you can't do the heavy lifting that you had to do as a mechanic. Okay, so let's meet our petitioner here. Carmen Campbell, I don't have a picture of her, was a hotel maid who developed a back condition that kept her from working. Campbell was born in Panama, and though she had limited ability to speak and write in English, she could understand when other people talked and she could read. Now, the administrative law judge in her case followed the grid and found that she was not disabled. Again, according to SSA and the Department of Labor, there were a significant number of jobs in the national economy that she could still perform. And so why did we have this grid or table? And by the way, for my students, this is why we're studying this case, is it's not just about Social Security, it's not just about disability. A lot of agencies actually promulgate these tables or matrices as part of their regulations to try to either streamline or make more uniform the decision making in local offices and hearings and with different hearing officers. In some ways, it removes some of the discretion from the retail end of the decision making for the agency because they have a table that people will just follow. And so let's look at this. In Social Security history, the administrative law judges had been deciding on a case-by-case basis whether there were enough jobs available for various claimants, who had, let's say, a medium work limit from their doctor or a light work limit and so forth, to find employment. And so this was a very case-by-case, and as you can imagine, a more generous administrative law judge might think, well, I don't think there's any jobs that this person is going to find in this area and so forth. So in order to streamline the decisions and get more uniformity, the Social Security Administration collected massive amounts of data on the availability of jobs for people based on these different work classifications: heavy, medium, light, sedentary, and based on their age, their literacy, their work history, and their transferable skills. Another advantage for the agency was that this eliminated the need for a vocational expert. That's someone who's an expert in how many jobs there are and what people with different limitations, what kind of jobs they could do. By the way, for my students, there's a very nice description of this grid or table in the casebook that you might want to take a look at. And again, this is going to be useful for other agencies. We're going to have other cases later in the course where an agency is following a table, for example, on whether to approve proposals for a nuclear power plant based on what the table says for disposing of the radioactive waste. Now, workers who fit within the grid are statutorily disabled and do not have to meet the listings. It's very difficult to meet the grid, to meet these requirements for younger workers who are only mildly impaired. So if you are under 45 and you can still do, let's say, medium level work in terms of lifting and standing and stairs and so forth, you're probably not going to meet the grid. And so the grid was controversial when it first came out because claimants were used to having the chance, and their lawyers, the lawyers who represented claimants in this area, they normally would have had the chance to argue that there were no jobs for someone, let's say, with only with a light work only restriction. So here's the big holding about hearings for those of you who like to write down the black letter law or highlight something in your casebook. The court upholds the grid. They say it is fine for the Social Security Administration to rely on it in making determinations rather than, let's say, the claimant's testimony. They also held that the Social Security Administration is not required to notify the claimant of specific jobs they can do, although usually when the record from the Disability Determination Services will mention some DICOT listings, that's the Dictionary of Occupational Titles from the Department of Labor, that they think are available for workers like this one, like dial marker is one I used to see all the time in practice. Note that the Social Security Administration does have to allow the claimant to present evidence of special factors or considerations in their case that might offset their grid categorization. So we normally don't do this, but if there's really extenuating circumstances or some special factor for this individual, we might consider that. Now, I'm not going to discuss the concurring opinions at length in this video, but that last point that I have on this slide really mattered to the concurring justices in this case. Now, I want to say something else about official notice, because that's part of the takeaway from this case too. This is sort of like the administrative law equivalent of judicial notice in civil procedure or trial practice. Section 556E of the Administrative Procedure Act allows agencies, and therefore administrative law judges, to take official notice of indisputable facts, or at least undisputed facts. And in this case, the circuit court had framed this as a problem of the agency taking official notice of something that was actually open to factual dispute, and the Supreme Court rejected this. But please take note that there remains some lingering uncertainty about the parameters of when can an agency or an administrative judge, a law judge, take official notice of something and skip some steps or not have to have substantial evidence in the record when we're talking about formal adjudication. And just as an aside, formal adjudication normally means that we require on the record decision making, and later on when we get to standards of review, it's substantial evidence. And altogether what this means for right now is that we're using formal adjudication, and any of the findings are supposed to actually be based on evidence that's in the record, that you could flip to the page of the record and find it. And so when an ALJ starts taking official notice of facts that are just general facts out there in the world, instead of having evidence to support each finding in the record, it's a little bit in friction with the way we normally think about the substantial evidence test and on the record decision making. Here, though, the Supreme Court says there is a certain amount of latitude for ALJs to do that. Okay, here's a review question to see if you've been paying attention. Can agencies use rulemaking to streamline some of the determinations that would be made in statutorily guaranteed hearings? So if the statute says you get a hearing, can they use a table, let's say, to streamline the process? A, yes, agencies can use APA rulemaking to promulgate tables or grids that control the outcome of many agency adjudications despite the private party's extraneous evidence. Or B, no. If the statute says that certain agency decisions must be made on the record after a hearing, it implies case-by-case analysis of all the facts and circumstances. Now, I know that's a mouthful, but hopefully you know the answer. And if you don't, this was supposed to be an easy question, you really should go back and review this video. And that concludes our lecture about Heckler v. Campbell.